Good afternoon, everybody. Welcome to the topic of discussion in this session is the growth of sports arbitration in Kenya and globally. I will very quickly introduce the panelists. I'm sure you have already gone through the pamphlet that has given their details, but I'll just do it in summary form. I'll start with the lady on my left. Her name is Sarah OCHWADA. She's an advocate and who has specialized in sports law, and she's handled arbitrations locally and internationally. Then on my extreme left, we have SHARAD Rao. SHARAD Rao has been a judge in the Court of Arbitration in Athens. He has previously served the government of Kenya as the head of public prosecution. Then the title was the Deputy Public Prosecutor. And lately, he has also been chair of the Judges and Magistrates Vetting Board. On my extreme right is Mr. John OHAGA. Mr. John OHAGA is currently the chair of the Sports Disputes Tribunal. And he's an arbitrator and has handled arbitrations both locally and internationally. And finally, he is a partner, or rather the managing partner, in the law firm Triple OK Law. On my immediate right is WILFRED MUTUBWA. WILFRED MUTUBWA is the vice chairman of the Chartered Institute of Arbitrators, Kenya branch. He's also an arbitrator, and he's also a lecturer at Riara Law School. I forgot to mention that Sarah is also a lecturer at Strathmore University. Okay, now to start us off, as you see from the topic, we're talking about the growth of sports arbitration in Kenya and globally. What I would probably want to ask the vice chair of the Chartered Institute of Arbitrators is, in a nutshell, to start this discussion off by telling us exactly what is this thing called arbitration, and probably contrast it with civil court or the ordinary court litigation.
Thank you. Thank you very much, Chairman of the panel. Again, speaking on behalf of the Chartered Institute of Arbitrators, we are grateful to have been invited in this session to share with you what we do. Now, to the question asked, what is arbitration? Generally, the Chartered Institute of Arbitrators is concerned with dispute resolution outside of court. There are very many other systems of dispute resolution, but because I've been asked to speak about arbitration, I will try and simply define what arbitration is. This is a method of dispute resolution where parties agree to go to a private person, some people call it a private judge, who is not a judge in a state court, to resolve their dispute. So it is a contractual arrangement between parties to refer current or future disputes to a person with special skills in that particular area to resolve disputes. Now, at the Chartered Institute of Arbitrators, we have over 100 years of experience in training arbitrators, mediators, and adjudicators. Now, we'll have to speak about that a bit later. But in terms of arbitration, what we do is that we train people in the skill of dispute resolution known as arbitration. These private judges that people eventually choose, we also appoint these people, and we generally promote the practice of ADR, or alternative dispute resolution. Now, if I may add a bit, that we have not been really leaders in the training of dispute resolvers in the area of sports dispute resolution. However, as times change and we expand the scope of our operation, we are starting to think about partnerships with the International Court for Arbitration, for instance, the Nairobi Center for International Arbitration, to see whether we can bring to Nairobi the expertise, the training in dispute resolution, including in areas of sports and entertainment. In fact, next week, if I may add, we have our very first annual sports lecture, where we are going to look at and explore the possibility of growing this area of dispute resolution. Perhaps later on I may be able to add, but we want to grow a community of dispute resolvers in the various sports, so that when people look at dispute resolution, they do not only look at courts and the tribunal where Mr. OHAGA sits. In fact, I'm reminded several years ago, my own experience was you would see people going to court to resolve disputes with respect to leagues and results in leagues, and disputes with respect to who should win a certain match. But you see, in actual sense, those are matters which the court is ill-suited to deal with. And those are some of the things that inspired the creation of the Sports Dispute Tribunal. And we think that there is an area of strength that can be found in training persons who will be the first ports of call for dispute resolution within federations, within organizations which organize sports, tournaments, and championships. So as the Chartered Institute of Arbitrators, we are ready to offer our expertise of over 100 years to prepare these people for this critical role, so that we keep sports disputes out of courts and we have people resolving disputes that are sports in nature before peers, persons with special knowledge but within the area of that sport, and eventually have sports as it's supposed to be decided on the pitches or on the fields, on the courts. Thank you.
Wilfred, before I let you go, is there any significant benefit of the arbitration process vis-a-vis the ordinary courts?
Thank you very much, Moderator. I will take a very simple example. You now hear of the goal line technology. Before then, there was a lot of complaint as to what exactly happens when there is an injustice visited in real time. The referee is a person and he is looking out to see an infraction and perhaps a game-changing infraction. That is an alternative dispute resolution mechanism. The video goal line technology that is real time is an alternative dispute resolution mechanism. So what we have identified as critical in dispute resolution in sports, number one, is the speed with which disputes must be resolved. So it must be expeditious. And that is what arbitration, mediation, tribunals such as the Sports Tribunal offer. Number two, it is the expertise, the specialized expertise. Now when you go to court, the judges you find there are experts basically on the law and nothing else beyond that. So you have an opportunity to have disputes resolved by experts. If you have a retired footballer, he is able to determine an offside better than a judge who has never been to a stadium, for instance. A table tennis umpire is able to resolve a dispute as to an infraction than somebody who has never seen a table tennis match. So you find the twin advantages of speed, expedition, and then cost-effective dispute resolution. You take 2 days to resolve a dispute as opposed to an average of 6 years, which is the average of cases in Kenya in one level of court in this country. So those are some of the advantages you get.
Thank you very much, Willie. Now, let me turn over to Sarah. Sarah, you have handled arbitrations locally and internationally, specifically in Qatar. Now, please tell us about what kind of arbitrations have you conducted locally and internationally, and I would want you to contrast that with the disputes that are before the High Court or the Sports Tribunal.
Okay. Well, to begin with, I'm an arbitrator, handled most of the disputes nationally for cricket and athletics and football. And internationally, I am still waiting for appointment to a panel to handle any specific disputes which occur within the sports circle in Qatar. So appointment is something else which I would like to touch on, and how parties within sports can actually appoint arbitrators to different panels. So within Kenya, we have a very interesting system. We have the Sports Disputes Tribunal, which handles a variety of cases, but most importantly, they handle anti-doping litigation cases. They handle appeals from the sports registrar. They also handle appeals from any decision concerning the team selection criteria. But I'm sure Mr. OHAGA has a better handle on all the jurisdiction issues that they handle. For me, personally, there are certain cases which are within the realm of very specific sports, which I am appointed to look at. So as an arbitrator, I will look at things to do with governance, regulation. If there's an election petition, whether someone does not want to be excluded from an election post, or whether there's issues to do with contractual disputes between clubs and coaches, or clubs and players, or even between clubs and the federation. So that's the variety of things that I handle nationally. Internationally, I've been on the other side. I've been counsel for parties within arbitration, and more specifically at the Court of Arbitration for Sport, which we have a variety of sports arbitrators who sit on the Court of Arbitration for Sport, and one of them is Mr. SHARAD, who's been at the Court of Arbitration for Sport. The sad thing is not many Africans are actually appointed to the Court of Arbitration for Sport, which brings quite a number of difficulties, especially when it comes to culture and language. When your client doesn't understand the regulations, which are very difficult, or when the arbitrators do not understand the culture from which your client comes from, there's always a bit of a conflict. Yeah.
Maybe you clarified with, to me, locally, you know, just like Willie said, you know, arbitration, there's some mutual agreement, and
yes,
that is how one gets appointed. Where do you get your authority for this appointment?
Okay. So in sports arbitration, there are two ways of getting authority to resolve a dispute. There's an arbitration agreement which is found either in your contract, which is going to be referred to as a specific reference to arbitration, or you have an arbitration agreement which is found in your constitutions of the federations. So that is known as a global reference to arbitration. So if you have two parties, let's say they have a commercial contract, supposing it's Nike and Athletics Kenya, they can choose within their contract to say, if any dispute arises from this contract, we shall take it to final determination by arbitration, either in the forum of Sports Disputes Tribunal or the Court of Arbitration for Sport, or any other arbitral tribunal they decide. But for everyone else, including athletes, your constitution determines where you will go for that arbitration. So, for instance, Athletics Kenya have within their constitution, you will go to this specific arbitration committee if there's a conflict or a dispute between the member and the federation. Anti-doping is a bit different. We are forced to go through the Sports Disputes Tribunal by virtue of the Anti-Doping Act and the Sports Act. So that's where you get the jurisdiction.
Yeah, just one small clarification.
Okay.
Now, within these constitutions, you say that there is some clause or something that gives you that authority.
Yeah.
Are parties utilizing that mode of dispute resolution, or are they always running to the tribunal or the courts?
It's funny because not all federations have their own internal dispute resolution mechanisms, although they should. So you find quite a number of parties who run either to court, and then they are told, no, you have to go back to the Sports Disputes Tribunal, and then other parties who fall onto the Sports Disputes Tribunal because they lack the internal mechanisms to go through their own mediation or arbitration processes.
Okay. Thank you, Sarah. We'll come to you a little bit later. Maybe now I can turn over to John. Now, John, just to build on to what the discussion I was having with Sarah, the constitutions of all these clubs and associations, they probably have clauses to do with arbitration and dispute resolution. Our constitution, Article 159, has really emphasized on arbitration as a mode of dispute resolution other than going to fight in court. Why is it then? Because as you answer this question, what I want to know is why are disputes really being settled within the first forum, that is within the organization itself through arbitration or mediation, or do they always come to you and to your tribunal? And if they do that, do you send them back to first attempt arbitration and ADR?
Okay.
Sorry, John, and as you answer that, please clarify to us, because we talked about arbitration and the ordinary court system. Where does your tribunal lie?
Yeah, that's an interesting question. The ideal situation is that under the second schedule to the Sports Act, it sets out the matters which every federation must have within its constitution. And that includes, number one, having an internal dispute resolution mechanism, and number two, recourse to the Sports Disputes Tribunal in the event of a desire to appeal or in the event of disputes which ordinarily cannot be settled by the internal dispute resolution mechanism. The reality is that even if a federation has a provision for internal dispute resolution mechanism, the question is, do they actually have a body constituted internally that would resolve those disputes? So what we would do at the Sports Tribunal is we would examine whether there is actually an efficacious method within that body, within that federation, that would resolve that dispute. Because the policy of the Sports Tribunal is that you must exhaust your internal mechanism. But we're not going to send you away on the academic assumption that you must go to back to your internal mechanism. Because if you don't have it, then we must find a resolution for your issue. And so on that basis, if we cannot find an internal mechanism, we will then take it on. But you must then make a distinction in relation to the matters that would have to come to the tribunal because they are required to come to the tribunal by legislation. And to that extent, you ask, is the tribunal a normal court? No, it isn't. It is a specialized tribunal created to handle sports disputes. And the reason that we require the tribunal is because the reality is that arbitration is expensive. If athletes, if sports people were to go to arbitration in the strict sense of what WILFRED has described, they would not be able to afford it. Arbitration can only grow in tandem with the commercial viability of sport. So for instance, when you look at the more developed countries, you look at England, for instance, they've got sports resolution, and they have QCs who sit there and, if Wayne Rooney had a dispute with Manchester United and took it to arbitration, he can very easily afford the fees of the arbitration tribunal as well as his own counsel. We have many, many times when we have players coming before the tribunal who have been denied their wages by a club. And when you look at those wages, it's 25,000 shillings per month. You know, believe you me, 25,000 shillings per month is not going to meet WILFRED's hourly rate as an arbitrator. So therefore, the tribunal must plug that gap. And so the tribunal mitigates the fact that we cannot, in fact, have an effective arbitration in the strict sense of the word available to our sports people. And therefore, we have a statutory forum to which they can come without cost and be able to have their disputes resolved.
Okay. Maybe one other question, John. This tribunal is made up of experts, dispute resolution or majority, lawyers who are specialized in the area of sports. Now, I would like you to comment as regards challenges that go probably to the higher court. I don't know whether that has already happened. That is the High Court. And we know very well that the purpose of creating this tribunal is such that the members there understand sports, the members there understand how the sportsmen, the way they manage themselves. And then you have instances where probably a court, the High Court, which is a more superior body, has to come and probably make changes in whatever decision that you have made.
No, that's not available to the court. There is no right of appeal to the court from decisions of the Sports Tribunal. The decisions of the Sports Tribunal are appealed to the Court of Arbitration for Sport. So it is kept specialized, it is kept narrow, and it is kept expeditious. Having said that, we know our own litigation culture in this country. So what happens is that losing parties find a clever way. They will try to go for judicial review, which is to go to the court and say, the tribunal didn't give me a hearing, or the decision of the tribunal was unreasonable, or the tribunal was not properly constituted. So as experts in both sports and law, it is our responsibility, when we hear matters, to ensure that we do not give them leeway to be able to go to the court and advance those arguments. Of course, people do try. I'm happy to say that, so far as I'm aware, we have not had any decision of the tribunal reversed by the High Court on the basis that we overstepped our jurisdiction, or we were improperly constituted, or a decision that we made was without a proper basis.
Now, just one last question. Now that you say that appeals from the Sports Tribunal would ordinarily go to the Court of Arbitration in Sports, isn't it? Mm-hmm. Now, and you had already commented and said, some of the litigants, it may not be possible for them even to, go to arbitral tribunals for dispute resolution. How possible is it now that a litigant will be able to manage an appeal in the Court of Arbitration in Sports? Would they come here to Kenya, or would the dispute still be had out there?
Well, as Sarah will tell you, the Court of Arbitration for Sport, and as Mr. Rao, I'm sure, will also tell you, can organize its mechanism to ensure that you have access without having to go there. So you can file your papers, you can have your appeal considered on the basis only of documentation. There is, of course, a fee to be paid in terms of a filing fee of sorts. And I think there's also a provision that allows them to waive the payment of any fees on the basis that you're an indigent party. So there are those mechanisms, and that's the benefit of a mechanism that is not a court system, that is sensitive to sports people, and that allows access. So there are those mechanisms, and also mechanisms to fast track the hearing of both sports disputes as well as doping violations.
Okay, thank you, John OHAGA. Lastly, maybe we can come to SHARAD Rao. SHARAD Rao, probably in a summary form, you can just tell us your experience at the Court of Arbitration in Sports and your arbitration in the Olympic Committee. What exactly went on there, so that we can try to contrast it with what we are doing here in Kenya moving forward.
Court of Arbitration, as John said, it is based in Lausanne. And it has on its panel something like between 250 to 300 arbitrators from all over the world. And there are those who have expertise in sport. So most of those who sit there as arbitrators either are former sportsmen or have done administrative been connected with sport, but they are all sort of familiar with sporting matters. So that is one qualification that is required, whether you're a lawyer, whether you're an engineer, whether some other professional, that doesn't strictly matter, so long as you have knowledge of conducting arbitration and you have knowledge of sports. Right? Now, the Court of Arbitration is now accepted as the final authority in sports. All the federations, at one time FIFA was very reluctant to submit itself to the Court of Arbitration for sport. But a few years ago they also agreed, and now all international sports federations accept the jurisdiction of the Court of Arbitration for sport, including the International Olympic Committee. You asked me about the Olympic Games. Now in 1996 was the first experiment that they made of having an ad hoc panel to sit at the games itself. And that was at Atlanta in 1996. Now the ad hoc panel, and I've sat on 3 of them. I was one of the judges in Athens, then I was at Beijing in 2008, and then I was also in London at 2012. The ad hoc court has jurisdiction over all matters that arise, all disputes that arise during the games. And they render their decision within 24 hours. Within 24 hours of filing of the complaint, all the pleadings, the hearing, and the judgment is delivered within 24 hours. Typically what happens, and this is what happened to me also, that when you go there, you have full accreditation for the games. You can go to any of the events, you're given a car, you're given a driver, and you're given a mobile phone, right? If a dispute goes to the Court of Arbitration, then the president of the court appoints 3 members from among 9 or 12 who are on that panel for those particular games. And you get a telephone call to say you are required. There's a dispute, you have been appointed. So you leave everything that you have and you rush to the office of the Court of Arbitration for Sport. And there you are locked in for 24 hours. You don't go out. So until you have finally heard the matter and delivered your decision. So that is the beauty of that one. Now for the Olympic Games in Tokyo, they're even going a step further, that even all the doping disputes, which first went to the International Olympic Committee, will now be referred in the first instance to the Court of Arbitration for Sport. So their jurisdiction has been extended for that. Typically, the court then decides on disputes, but you made a reference to what we call the field of play decisions. The courts are very, very reluctant to get involved in what we call the field of play decision. Because where an umpire has made a decision, where a referee has made a decision, he is, so long as that referee has acted honestly, without bias, without any degree of influence or corruption, then the court will uphold his decision. All right? Because it's not then for the court to say whether that goal should have been allowed or not, whether he stepped outside of the line or not. Those are decisions which are left to that particular body to, yeah? So the court will not interfere. We had a very interesting matter where we thought for the first time that we would intervene in what we call a field of play decision. And that was in Athens. What had happened in Athens, that what is that event? There was an event where there was a Korean athlete as against an American athlete. It was pole vault. And the favorite was this person from Korea. But something went wrong during the competition itself, where they gave wrong, there are the point system. So the Korean was awarded wrongly less points than he should have been awarded. This was accepted by everybody. When he actually lost to the American, quite unexpectedly, what happened was that there were statements made by the president of the international body. He said that decision was wrong. When they suspected that decision was wrong, they rushed to make an appeal. When they rushed to make the appeal, by the time they filed the appeal, they were already out of time, all right, on that one. Now, when we looked at this, because everyone was admitting that it was a wrong decision, so for the first time, the three of us who were appointed to this panel said, this is one matter in which we are going to intervene, all right? Now, what the Americans did, in order to protect their athlete, what they did is to send him out from Athens, so that when we said we didn't have the American athlete there. So the only one we had was the Korean. So we then adjourned the proceedings to Lausanne, where we said that they must, both of them must appear with counsel if they want to, and a decision will be made with or without them before us. And they all turned up. The night before, the three of us met, and again we were of the same view that we were going to allow that appeal from the Korean. So in the morning, at breakfast, we were still of the same view. Then the hearing starts. And a very interesting question was put. And they were very friendly. The Korean and the American, the two athletes were very, very friendly. The bodies were not. Their national bodies were not. They were at loggerheads. But the two athletes got on fine. They would have accepted whatever would have been agreed. Now, one question that was asked to the American, and said, do you agree that the points that he got, I think it was 9.8 or something like that, was wrong? All right? And if you would have had to beat that 9.8, but what was given to you was 9.2 to beat, all right? You accept that? He said, I do. If it was 9.8, would you have been able to beat that 9.8 score? So he looked at us and he said, it's a very speculative question. I would have said no, but who knows? If I had been asked to actually go over to challenge the 9.8, perhaps I have reason to it, perhaps I may not. You as arbitrators, can you say that I would have or I wouldn't have? So we all looked at each other and we said we can answer that, all right? And we actually rejected that on that ground. We said, no, we can't interfere with this because we don't know. It's a pure matter of speculation.
Okay, thank you. Maybe before we go to we give the audience an opportunity to ask a few questions, maybe any of you probably can just guide us. What normally happens, you know, sports disputes are very unique because we have also minors. So how do we go about it in the tribunal and maybe in arbitration proceedings? Anybody amongst the panel?
Well, minors will have guardians or they will have managers. So they will have a designated person who is responsible for them. And so therefore, that is the individual who will propel the proceedings, so to speak. Because, you know, minors are in sport. Minors can be guilty of doping, for instance. Yeah. So somebody has to step in and defend them, instruct counsel, and so on and so forth. So very much in the same way that you deal with it in civil proceedings, where you have a guardian, you will have a specially designated person to take care of the interests of the minor.
Okay. Thank you, John. Maybe we can take a few questions from the audience so that they can take advantage of the expertise of the panel.
You have any question? All right. My name is.
And please state your name, and then if you're from an organization, please let us know.
Daniel Wahome, Kenya Broadcasting Corporation. I would like to make reference to some decisions made by the Sports Dispute Tribunal. I think, and this has got to do with how truthful a person can be. And maybe I think the chairman and Sarah, who has been counsel for some athletes there. The case of Jemima Sumgong, where she gave false information about medication KNH. I think if I was at the High Court, I would be sent to the coolers very quickly for that. But in that case, it was picked up by the Athletics Integrity Unit as a second violation. So how do you deal with that? Because it's, the fidelity for whoever is there how do you deal with that? And in case, for Sarah, if a person you're representing does that, then where does that leave you as a defender?
Okay, thank you. Maybe we take a few questions and then I can allow my panel to address them. Behind there.
Okay, my question is, in terms of, in the beginning we said that this...
name, please.
My name is Shafik Tebji. I'm also an arbitrator and a mediator. My question is, first, when we initially mentioned that the arbitrators, there would be specialists, like for example, a coach or a player, I think your panel needs one of those people in the future, so that we be able to talk to them directly in terms of being in the field. The second question would be to the lady, being the only lady even on this panel, and being there with the men arbitrators, what would you say is your contribution in terms of improving the sphere in which you operate, and what would be your contribution in terms of the sports, in terms of including other ladies and the field that you're in?
Thank you.
Okay, good afternoon, everyone. My name is Milton Nyakundi. I am a freelance journalist and editor for Kurunzi News. Mine, I think, is to Chairman. I have had occasion to attend some of the proceedings, and one of the things that has come out is the quality of submissions that you get, which sometimes has given you the burden to even guide certain litigants before you. How does that then affect, at the end of the day, are those considerations that you make, that sometimes some of the submissions, maybe you see the point, but it doesn't come out either through the counsel representing the litigants or even the witnesses that come before you. Do you strictly operate and say if the counsel or if the litigants didn't bring them out, as much as you may understand, you would then throw that out of the window? And the second question to Sarah is, Wahome has already talked about it, but I'm thinking, unlike ordinary courts of law where you're strictly defending a litigant or representing a litigant, how does it play out for you as a lawyer when somebody comes to you and maybe they have done whatever, it could be doping, for example, and they are guilty of having violated that? How does that pan out for you from that point moving forward?
Okay, I think we can probably answer those 5 questions. Maybe we can start with the ones which were directed at specific panelists. And I will start with John. There is a question by Newton as regards the quality of submissions, and I think even what he's feeling is more of do you have to come out and assist the parties? Because we know generally most of the time the courts sit back and let parties bring their submissions. So please respond to that, John.
No, allow me to deal with Jemima Sungong first.
Yes.
Because that was a decision of the tribunal, and I wrote the decision. You see, there is a jurisdictional issue. We get our jurisdiction with respect to doping violations from the Anti-Doping Act. The Anti-Doping Act is very specific that the tribunal will not have criminal jurisdiction. So, when a witness lies, the imposition of a penalty for that is in the realm of criminal jurisdiction. So our remit is to recognize that the party has lied, which we did. We recognized very clearly that she had lied about her adventures at Kenyatta Hospital, and we imposed the maximum fine, the maximum sanction allowed under the WADA code, because the anti-doping rules very much follow the WADA code. Now, what has happened is very interesting with respect to athletics, is the Athletics Integrity Unit has added another layer and actually almost departed from WADA. And, you know, when they hit her with an additional 8-year, I think, sanction, that goes beyond what WADA would be able to issue. So the Athletics Integrity Unit is Sebastian Coe's police unit to police the athletics environment, and it is completely unique to athletics. You will not find it with any other sport. And if it was ordinary, if it was in the realm of ordinary law, and Sharad, you can correct me if I'm wrong, there would be a double jeopardy argument. Yeah? There's what is called double jeopardy. I have already been tried for this offense. I have already been sanctioned. It didn't go to athletics integrity as an appeal. They just took it up to retry her. And you see, that's the very interesting thing about sports jurisprudence. It was not available to her to argue that that would constitute double jeopardy. So I don't know if your suggestion was that somehow we let her off. Pardon? So now what should have happened is that the Director of Public Prosecutions should have picked that up as a separate criminal offense and tried her for it separately, because that's now in the realm of the criminal justice system, and then imposed a sanction which could include a prison sentence and so on, because obviously there was lying there was tampering with evidence and so on and so forth. So that's where it lies. Now, Nyakundi, with respect to your question, as Sarah will tell you, the tribunal bends over backwards to assist counsel, because I am particularly conscious of the fact that, number one, sports law is relatively new in this country. You won't find many people like Sarah who come in already knowing what the points are that they should argue and being able to address the full spectrum. So we are very careful to assist counsel, to fill in the gaps, and sometimes to point them to where they should look. So for instance, with doping violations, where we have hapless young athletes coming in with no knowledge really of what they are facing, we have created a pro bono panel of lawyers who we will assign to those athletes. The purpose, number one, is to grow the skill among the lawyers as to what is available to them within the doping environment, the arguments available, and to guide them and to tell them what it is they should be arguing, what it is they should be looking out for. In that sense, we don't act like a normal court. We are not passive at all. Yeah? The normal court would say, that's your case, you argue it. If your submissions are inadequate, that's your funeral. If submissions are inadequate, we will fill in the gaps for counsel or for the party, and then we will try and come up with a decision that is as comprehensive as the justice of the case requires.
Yeah, I think that one of the things or issues that I think members of the legal profession probably, and I'm just getting the feeling of where it's coming from, is I can understand trying probably to assist those parties who are unrepresented and do not understand the procedure. But the minute we have an advocate, there's an advocate representing a party, and he seems to be guided towards one side, the other side will always feel that tribunal has been probably unfair to me. That's probably what I don't know how you...
Well, that's the problem, because you're now thinking like a litigation lawyer. Yeah. When I leave my litigation and I'm in the sports tribunal, I think very differently about how to resolve those disputes. And there's a way in which you can guide parties without prejudicing one or the other. So you give them the benefit of that argument, and then you ask the other party to respond. Yeah? This is the argument. What is your response? And it very quickly narrows the issues. And once people come to an understanding, there are many times actually where we don't even have to render a decision because one advocate has conceded and said, oh, if that's the case, then I see the point. And I abandon that point.
And it saves time.
Yeah, so it saves time.
Yes.
You have to change your thinking.
Yeah.
SHARAD has a point to say.
Not on this, very interesting. Outside of the sport, an arbitration matter where I was involved, nothing to do with sport, outside of sport. This was between Iran and US. And I had gone from here, I was transferred from here to The Hague as an independent arbitrator between Iran and US. And what would happen there was that the Americans were represented by a battery of lawyers, top lawyers from America, whereas the Iranian would have one lawyer. And that one lawyer appeared in almost every case that the Iranians had. And what he would do when we had allocated them time and say, you're 1 hour or 1.5 hours, then you're half an hour to reply or whatever, the Iranian lawyer would take us through what had happened in Iran as to how the Shah of Iran and the American governments had colluded and all the injustices that had been carried out, which led to the revolution and all that. So we would listen to that in every case, the same argument. Right? So I would intervene, and I would tell the Iranian lawyer, I said, look, you've been given 1.5 hours. You've spoken for 1 hour, got half an hour left. Now please, can you address us on the legal issue? So then I had a knock at my door. The American ambassador sent his representative to meet me. So he came and he said, I've come from the ambassador. I said, yeah. He says, we have a message from the State Department. They want to offer you the green card to go to America. So I said, thank you very much, but I don't want to go to America. I've been sent here by the government of Kenya as an independent arbitrator. When I finish my job, I go back to Kenya. They said, but everyone who's come here, they've always wanted to go to America. I said, maybe. Thank you very much. I don't want to. So he then turns around and says, but the State Department's not happy with you. So I said, a moment ago, you were offering me the green card. Now you're telling me the State Department's not happy with me. What's the matter? He said, you know, they say that you help the Iranians. So I said, in what way? He said, look, if they're arguing a point and they don't bring up a legal issue, why do you intervene and ask them to raise the legal issue? I said, look, as an arbitrator, it's my duty to see that justice is done. And until I hear the argument, how am I going to do it?
Exactly.
So just to give you an example of how at international level they try to influence you or bribe you, like with a green card or something like that, to go to America so that you can rule in their favor.
Yeah. Okay, thank you very much. I think we just have 2 more questions. I think Shafiq, you are asking about experts within this panel or the tribunal? Yes. No, I get it. Yes. Yes. I think the organizers are here and they have probably heard you. So the last question we have not dealt with.
Just to put your fears to rest, I played sport for Kenya. And so I don't speak about it theoretically. I played sport.
You also played.
So I have the theoretical aspect and I have the practical side. I have the heart of the athlete and the intellect of the lawyer.
Shafiq also, I think our vice chair played sports also. She did also play sports. So.
Okay, I think that's something we didn't know. So thank you for telling me.
Okay, now maybe the last question we can deal with. This was, Sarah, you asked this question, I think, by Newton. Newton was asking, how do you deal with your clients when they have come and not really lied, maybe disclosed to you that I'm guilty of doping or this and that? How do you manage that? I think it's more of a legal question, but...
Oh, well, there's 2 sides, well, 3. So the first thing is anti-doping violations are strict liability offenses, meaning you are guilty, and so my job is to try and mitigate the amount of punishment that you're going to get. Punishment will come, My job is to find enough evidence to reduce it. So if you lie to me as your lawyer, it just makes things worse for you, and you might get the maximum punishment, which is a 4-year ban. So what I explained to the athletes is, this is the type of violation you cannot run away from, number one. Secondly, you are definitely going to get a sanction, but depending on the facts and the evidence that you adduce, we can help either reduce it to 2 years or just a warning, depending on what we find. So it is in their best interest to tell me the truth, the whole truth, and nothing but the truth. Unfortunately, I've had situations where athletes have lied to me, in which case there's some cases I have withdrawn my counsel because I cannot possibly represent someone in my conscience who is attempting to cheat the system. The other case is an athlete who you may or may not have heard of in the news, who came to me as a female, but after a few years, we found out was actually a man. Now, this is an athlete who had come to me, had said, I am a woman, I have a child, I've been abandoned by my husband, we commiserated, I took her to my office, helped her go into the ladies' room. And so you wonder, at what point did this person, there was a transgender happening and no one knew, but also I kind of thought back to even the doping control officers must have been hoodwinked, or there was some witchcraft involved, because in doping control, there has to be an unobstructed view of urine passing from the body into the collecting vessel. So in your nakedness, how could you dupe a doping control officer? But at the same time, how is it that all of us were duped to believe that this person was a woman? So that's a different kind of lie, which even I think I need to go for counseling and a lot of therapy for. And then lastly, I think Shafiq was asking about what do I do to expand the opportunities for women in the space. I think it's more than just women. It's expanding the opportunities for everyone in law and even as professionals to join in sports and sports disputes arbitration and sports law. So for me, I just started as myself. I didn't think of myself as a woman in the industry. In fact, I'm a recovering lawyer. I tell people I want to quit every day, but I'm expanding the space slowly, number one, by teaching. So that's what I do a lot in the university, by training. And we're having our first training for lawyers under the Center for Sports Law next week. And also trying as much as possible to include other people in a lot of the cases that I work on. And even internationally, pushing forth African practitioners to go into those arbitration panels. Because if it's just me, the only black face, the only female face, the youngest face, there is a problem. So that's what we're doing.
Thank you very much. I think we have run out of time, and I would want to appreciate the panel that has been here today. Probably can just give them a hand.
Thank you so much. And
thank you very much for the insightful discussions.